Yes, welcome to a first edition here that we're doing this live here on the No Stay Project. And we're going to try to do this, at least every Thursday. Same time I usually do the regular show at 3 p.m. Pacific time, with the West Coast time here in the United States. I guess it's 6 o'clock there on the East Coast, so 6 to 7 p.m. on the East Coast, and it's Friday morning there in Australia. Probably about 11 right now. But glad to be here. I will be a little less professional as far as how I gauge things. So if other people want to join the show, it's not really a show. It's not a natural broadcast. But what we're doing here is, like I mentioned on the last couple of shows, we're going to be doing role playing and doing more direct court prepping. So people who are looking to prep for court, if that's what we're doing here on the show. So if you're going to call in, well, I prefer that you use the Skype for today. It's going to be on Frank Rizzo 3. So I'll put that in. I'll just type that out. Frank Rizzo 3 on Skype. So Skype is what we're using here today. So if you don't like Skype, well, nothing we can do about it today. Not the biggest fan myself, but hey, as far as the tech issues go on this show over the last 12 years, it's usually not Skype that's the culprit there. So, but I do appreciate appreciate people tuning in. Wouldn't it be a kick in the teeth if I got more live viewers to this than I did on the show? Hey, I'd be happy with it. I would be happy with it. So I've got somebody calling in. So what I'm going to do, we'll add him. That's what I mean about being a little less professional. So if I got to add somebody, I got to go over to the other computer. So, but we'll let that go since this is not a live broadcast of the regular show. Otherwise, we wouldn't necessarily do that. So I don't have the opportunity to individually mute anybody. So if people start talking over each other, I'm going to just mute the entire line and get things back on the control. So I'm going to be the main moderator here because of issues that we've had on the chats. So hopefully this is going to go a little more smoother. And the idea here is it's not a regular broadcast. What we're doing is just prepping for court. We want to do role playing and we're discussing some of the basics about going in and defending ourselves. So just because of this, it's not the time to get into a long, drawn-out narrative like we do sometimes on the show regarding what kind of case that you're facing. We just want to get a couple of details, know where you are, what kind of how much prepping you've done before, and then we'll get straight into it. I may or may not participate I may just sit in as a moderator. So hopefully, we're going to go to about 4, so about an hour's worth. We're going to be doing here today. So, and this is not the opportunity to call and disagree, if you're a critic. That is for the other shows. Unless I'm giving, we're talking about something here and it's just wrong. So if you have an issue with anarchy, this is not the platform for you to voice an argument or complaint against that. If you think that there is evidence proving that the Constitution and laws apply and that the government isn't actually a moral and ethical organization, this is not the platform for that. That's for the Wednesday show and the Saturday broadcast. This is just for court procedure. So dare I go and unmute? So I don't know how many people we've got on, but it looks like it's at least five in addition to me. So we're unmuted. So I don't know. We'll see how this goes with so many people on the conference call. Well, let's see. Who do we have on the line that actually needs to prep for court because they have we'll give deference to somebody who's actually got a court appearance coming up?
I do.
Okay, and yeah. You are?
I'm Dominic.
Dominic. All right, Dominic. And when's your court date?
No, home bumming it.
Oh, I
That's
really
all.
messed that up. Okay, so home bumming it.
Yeah,
Okay, home bumming. Okay, so when is your court date?
12th next month.
Next month, October. Okay, so you got a few weeks to still prep.
Yes, sir.
All right, good. Now, do you have any questions regarding the basics, regarding the principles that we talk about on how to effectively defend yourself?
Well, last time I tried role playing with you, doing a moderation, usually I've been trained to go through the first 5 or 7 questions in the judge's ethics scorecard, and you wanted me to get straight down to the jurisdiction, evidence of jurisdiction. So is that what I should do again, or should I go through the 8 questions?
Let's do it and just jump right into the actual jurisdiction. I want to, at least the time that I have doing this, I want to spend it on a more likely scenario that we're going to go through if we are in court. And you're in California, so it's more than likely that you're not going to have an individual on the stand that has a professional demeanor about them and has any actual patience to deal with other adults. So that's why we want to go right for the throat. So do we have somebody who wants to play the judge and somebody who wants to just sit back and maybe be a prosecutor?
I'll be your prosecutor.
Who's that?
The dude.
The dude. All right, dude. The dude could abide being a prosecutor. Who wants to play the judge? Do we have someone to do that? No one?
Well, if nobody wants to volunteer, I guess I'll be forced into it.
Okay. And who will we forcing?
We're talking to Stal.
Oh,
That's the little nickname.
all right. All right, Stal. Okay, so home bumming it. What we're doing over here is we already know from watching other people that Tom can play the judge too if you don't want to do that, Stal.
Let me have a stab at him.
Let you have a Stal at it? Is that
Oh, no. Yeah, right. Let me have a Stal at it.
okay? Well, all right, Tom. You just sit in the wings there, and we have plenty of time. Stal might hurt the poor guy. Wow. The idea is so that if if people have a weakness, let's have it come out now, not when you're standing in court. Okay, so we got the dude, Stal, and home bumming it. You are the defendant, so take it away, Stal.
Mr. Homie, I see in front of me that you've been charged with sitting on your butt on a sidewalk, pursuant to Criminal Code negative 37. How do you plead, sir? Guilty, not guilty, or nolo contendere?
Am I innocent? Am I considered innocent here today?
Sir, everybody is innocent and not guilty at the same time. So how do you plead, sir?
What evidence has the prosecution provided to show jurisdiction over me?
Well, sir, the prosecutor has provided the prima facie evidence of us to hear this court case. We're hearing the court case and we're moving on. Guilty, not guilty, or nolo contendere?
Well, I entered a motion. Has the prosecution submitted evidence sufficient to overcome my motion?
Well, sir, that's a motions hearing. You can apply for that next time or tomorrow or later today. But right now, I'm just a plea judge. I'm just here to take a plea. Guilty, not guilty, nolo contendere. It's very simple, sir.
Well, let me just jump in here. It's in California, keep in mind, it's called a demur. Now,
Sorry.
I don't think it's a big deal. I think they're really the same thing. But when you've got these arrogant lawyers, and we know this since we've been in the court, we even have a couple that will, go off the deep end and be triggered. Oh, he's using the wrong word, even though for them, that tomato, it's the same way. Any opportunity that they have to make us look bad, that we, especially if you're in a criminal situation in California where they want to put a lawyer on you, if we start, look, there's not too many words that we need to know, but if we give them an opportunity, yeah, look, you give these criminals an inch, they'll take a mile, right? That's how it goes. So the other thing is, since if you have a motion or a demur pending, that should be what we start off with. So right out of the gate, if they're asking us how we plea, well, objection, there is a demur pending. Okay.
All right.
So let's take it from the top. We're actually getting some good numbers here, though. So, hey, I appreciate that.
All right. So it looks like we have a demur in front of us. Let me look at it. Flips a couple of pages. Interesting. Well, I don't really see any merit to this. Denied.
Stop. Let me just jump in. I'm sorry. You guys, this moderation is probably going to start driving you guys crazy. 99% of the time that I have been in or other people have reported to me, they sometimes they're not even aware that there is a motion or a demur pending. So let's do this where you're just asking him to plea and it's up to him to bring up the demur.
Yeah, that's what happened before.
Yeah.
Okay. So I'm sorry, sir. How do you plead again?
Sure, I got a demur. I gave you guys a demur. Did you get it?
I see. Where's this demur? I don't have a copy of it.
Maybe I gave it to the clerk. I mean, does she have it? I gave it to her.
I have no idea. I'm just sitting here on the bench. If you want to stop everything and call the clerk, I'm sure that would be inappropriate. Do you have a copy with you right now, stamped by the clerk, showing that you actually filed it?
No, I gave it to the clerk that's sitting next to you underneath your bench right there.
Oh, that clerk. Oh, there we go. I see it now. Yeah, let me look at it. Interesting. Yeah. Denied.
Okay.
Okay.
Has the prosecution submitted any evidence to sufficiently overcome my demur?
Well, at this time, I don't see anything in front of me besides the prima facie case to go on with the case and just get a plea from you. I've already denied your motion, and we're moving on. How do you plead, sir?
Well, what in the motion do you think doesn't have any merit?
I'm sorry, sir. I've just told you that I've denied it. If you'd like to know why, you can go take a 7-year law school course. And until then, we're moving on. Next.
Well, let me jump in again. I don't know if that's the way it is in Canada, but typically law school's 3 years, not 7. So I don't know what you're really trying to say to the poor guy here. I would jump in and see if anybody can. There was something wrong with some of the questions that he's asking, especially that last one. Somebody want to jump in and correct Home Bumming It on why the question he answered, the form of the question he answered is not what we want to do?
From what I noticed, he's looking for what has been provided, whether anything has been provided or not, has not been asked.
Well, specifically what happened was he asked a non-leading question that opened the door for Stahl to go into a narrative and avoid the actual issues. So,
are the grounds to deny the motion based on prosecutor's evidence?
You want to say, yes, the question should be a leading question. So you denied you're overruling the demur because the prosecution does have sufficient facts to overcome the demur. So that's just a yes or no answer. It's not a narrative. He may give you a narrative, yes, but at least you'll be able to object and be able to show that objection is not responsive. Just
okay.
Please, just yes or no. Is it your? And another thing you can throw in there, home bumming it is. The guy read. I mean, if we're going in real time, and this has happened, they don't even have a chance to read the entire motion before they deny it. So that's something else you can keep. You know, you could say, well, objection. Did you read every page? It didn't look like it.
Yeah.
Well, wouldn't the first thing you'd be looking to do is find out if that prosecutor has opposed it in any way?
The prosecution doesn't have to oppose it. The judge is only able to go based on what the prosecution has presented. So,
But that's the thing, right? Is if it is unopposed, then we could look into what evidence he's relying on to oppose it. But if it's unopposed, then it shows right away that, you know, it should be granted, no?
No, an unopposed motion doesn't mean that it should be granted. An unopposed motion with merit, yeah. But see, here, all the judge is supposed to do is look at the record. So here he's got the police report, or he's probably just has a ticket. He has to look at the record before him. Now he's got a demur saying there isn't sufficient facts, and he has to look at the record, opposed or unopposed, doesn't matter. He has to look at the record before him, and he has to determine, do these facts, or are there sufficient facts here to warrant overruling this demur? Because the demur is saying there isn't sufficient facts. Does the record before me, support that? And if it does support that there aren't any facts, then whether the prosecutor took an opportunity to respond is irrelevant. The record is devoid of the necessary facts to overcome the demur. So it's kind of a common thing that a holdover from this Patriotcraft from the 90s, that an unopposed motion automatically means it has to be granted. I mean, the motion still has to have merit. I mean, judges are still supposed to be fair, impartial, independent decision makers. I know, cue the laugh track. And they still have to determine whether the motion has merit or not. So, I mean, imagine just because someone doesn't respond to a motion that clearly has no merit. I mean, what if it's one of these Carl Miller type things? Does that mean that just because the prosecutor or let's say I didn't take the time to respond to that they should automatically be granted?
Well, they bring allegations in that are unfounded and have no merit to them all the time.
That's true.
And they're forcing people under a threat of violence to be there. So,
yes, but the question is, does an unopposed motion automatically get granted? And no, I don't believe so.
No,
well, okay. So, yeah, I just forgot to mention an unopposed motion with merit, right?
An unopposed, but like I just said, they still are supposed to go through and make sure that look, your motion to dismiss or demur based on lack of evidence, that's a meritorious defense. Now, whether or it's a valid legal defense. Now, whether that the record, is accurately described in the demur, yeah, that's a different thing. But so I wouldn't want to see a rule that an unopposed motion is automatically granted. I would want to see that. I think the judge should do his job and determine whether there's evidence in the record sufficient to overcome the demur. Okay, and I got to jump in. Somebody is saying, how do I call in? The only way to get onto this particular call, and we're doing role playing. This is not a radio broadcast. It's no say project, but it's not a typical radio broadcast. And so you're going to have to join me on Skype. It's at Frank Rizzo 3. So if I get like we did with somebody earlier, I will go over there and I will join them to this particular call. And so far, I don't see that. So anyway, all right. So let's get back to this. We're discussing the demur. So Stahl, let's take it from the point that you're giving your decision on the demur.
I'd like to also comment that he's not even objecting, not even once, I think.
Yes, that's true.
And remember, as Mark would say, everything coming out of, majority of the times is just a bunch of lies anyways, right?
Right.
So you want to object?
Okay.
Yep. Okay, so Stahl, take it from you're reading over the demur and you're going to do
Right.
your thing.
So I've looked at your demur. These are quite interesting points, but I don't find any merit to them, so I'm going to deny it.
Objection. Point of clarification. Are the grounds to deny this motion based on the prosecutor's evidence?
No, sir. They're based on my opinion.
Has the prosecution submitted any evidence sufficient to overcome the demur?
At this time, they haven't done anything except file the prima facie evidence that is being held against you, and that's why I'm here to take a plea of guilty, not guilty. Nolo contendere, because we're just here to protect your rights, and so you can have a fair, independent, and impartial hearing on this and a trial. And I'm not sure if you understand this, but do you require a lawyer, sir? Because we can provide you one.
No, I'm good on that. Has the prosecutor described or submitted any evidence as of now that would justify the court's presumption of jurisdiction over me?
Well, sir, I've already repeated. They've only provided the prima facie stuff all over my desk here with a whole bunch of folders and files. I haven't even had time to look at them. I'm just here to take a plea from you, sir. I'm not a trial judge. And again, if you keep asking me the same question, I might have to ask you to be, 5150 checked out, because I don't know if you're quite understanding this stuff.
Fair enough. Then I guess I just got one more question about this. Is that all the information that the prosecution has provided?
Well, again, the prosecution hasn't provided anything. They've just provided the prima facie, the ticket, the allegation, the charge, the affidavit of service, the affidavit of all this voodoo and mumbo jumbo. And I'm just here to take a plea, sir. How do you plead? Guilty or not guilty?
Well, I motion to dismiss based on lack of prosecution's evidence.
Denied. Guilty or not guilty, sir?
Well, objection, point of clarification. Is the court presumed to have jurisdiction to change my status from innocent to not guilty?
Well, sir, the court has jurisdiction to hear these kind of matters. We have 200 years of stare decisis, res judicata. And if you have any questions about that, either A, hire a lawyer, or B, go upstairs in the library. You'll see it all there. And so we have jurisdiction here today to hear this matter. So please, guilty or not guilty, I'm losing my patience. There's like 500 customers behind you.
Oh gosh. Well, let me jump in
With
here
all
because
due respect, Your Honor, I'm not the one bringing false allegations to you. I'm not wasting your time. I don't, I'm just trying to investigate this.
Look, I got to jump in here because there's a few things going on, but I don't want to be the only one pointing it out. This is also to help other people. One of the big things is home bumming. You need to be objecting and calling out the obvious contradiction that the judge has done at least twice. He has said that they don't have anything, and then he turns around and says, but they have prima facie. So it's either they don't have anything or they do, and then you can move on. Of course, what specific facts would support those, or what facts in the record actually prove that your Constitution apply to me just because I'm physically in California?
Okay.
So why doesn't somebody else take and bring up some of the other things why you believe home bumming it is not having a good time right now with this judge?
I think it's because I suck at this, but go ahead.
Well, this is for everyone to learn. So I want others to point out. Dude, you got something to weigh in on here? Or do you think that I covered it?
No, I'd like to hear how you cover it.
Well,
I spent too much time doing it.
Well, I already went through and said he was not objecting. I think I hit the big ones. Right? That the other thing too is he's not asking very good leading questions.
Well, and I think we went over that with him earlier. You got to look at what your result of the clarification or the question that you're asking. is going to be before you ask it. What do you expect to get from asking what you're asking?
And you don't always have to say point of clarification. I would just, just say objection. And what it comes down to is, if they want to know what your actual objection is, well, you're being very evasive. You're not answering questions directly so that I can make an informed and voluntary plea.
Okay. So I can say that.
Yeah, I would say that.
All right.
I want to just address some people. It's been thrown out that I have imaginary objections, and I will be the first to admit that I will make an objection just because something is unfair. In fact, I was pleasantly surprised to watch something from Irving Younger, who is a celebrated lawyer in the United States. And even he said, this is back in the 70s, even if you can't articulate it in the heat of the moment, objection, and just say it's not fair. You're making an objection because what is happening is unfair. Now, if that is something that's imaginary, at least it's shared by, the good thing is it's shared by one of the best trial lawyers the United States has ever produced, Irving Younger. The other thing too is you have to look at the result. If you're going into court and you're going to box in and just say, well, I'm not going to object to something that's obviously unfair, and I'm not going to do it just because someone on the internet may say it's an imaginary objection. No, you make the objection because what is happening is unfair. The reason why you say objection relevance is because if something is not relevant, then it's not fair. Every objection, probably comes down to whether, what is happening is unfair or not. So if there has not been in a law library somewhere, the actual objection that matches your situation, I think you'd be selling yourself short to not make the objection and articulate that it's unfair than to try to fit into a box that someone on the internet says that we should belong to. We all can agree here that what we're doing is unorthodox. It's kind of silly to then think that every single objection that is based on something that's unfair has to be something that lawyers have done in the past. I don't believe that we should be limiting ourselves to that. And I think it would be short-sighted, and it would be really ineffective to do that. And if somebody wants to say it's an imaginary objection, go ahead and who gives a damn? The results are what are important, not what somebody trolling us on the internet is going to say.
So can I go ahead and ask you a question real quick?
Yeah, of course.
All right. So, because I went in there and I said, look, I'm not an attorney. Okay. So, my paperwork might be off or something like that. I don't know exactly all the ins and outs of court procedure and all this stuff. So, I just want to speak plainly. And that's one of the reasons why I was kind of like with the not objecting, because it seems like it's something I don't normally would do. But I should. Is it okay just to go ahead and say, look, I'm not an attorney, but I'm trying to figure this out and understand what's going on so I can make a informed and voluntary plea.
You're those in California and other places like that, I don't think it's a good idea to say that I don't understand, because we know the next thing they want to do is either force a lawyer on you, order a psychological evaluation, or both. There's a world of a difference between being informed so that you can enter a voluntary and intelligent plea and I don't understand.
I don't think I said I don't understand. I said I'm not an attorney.
Well, I thought that's what you said when you were just, telling me what was going on. But
no, I'm not an attorney is what I was saying.
Okay, I don't even know if I would necessarily, I think it's probably fairly obvious that you're not. They would have to assume whether you are or not. So it's not necessarily something that I tend to bring up. I want to be informed. I want to know what the prosecution has and what the judge believes is true at this point, so that I can enter a voluntary and intelligent plea.
That was actually one thing that Home Bumming it didn't mention, was what's the cause and nature of the charges. I didn't hear him say that either.
Well, that's not something we had spoken about that before. We're going right for the throat here. We've got a demur that's pending, and good to hear you, mate.
No worries.
We've got a demur pending already, and we're figuring we only have about 2 to 3 minutes to get this done before they enter a plea of not guilty, and we got to clean that up later. So that's why we typically in role playing we'll do that. I want to focus more on this instead of the other scenario where we may have an opportunity to get into some of the preliminaries.
So it's fine for me to object and say, what are you basing this, or what are you basing that on, or what are you basing your judgment on if the prosecution doesn't have any evidence?
All right, repeat that.
Well, if I'm talking to the judge and he says, that he just has a prima facie case, then is it fair enough for me to say objection? What are you basing the decision on if there's no evidence? Well,
the thing is, if you do that, it's an open-ended question, and you can get a narrative, as opposed to being direct on it with a leading question. Is it your position that the facts as pled prove your at least prima facie is that the Constitution applies to me just because I'm physically in California? That's a leading question. It's either yes or no. It doesn't give him, if he's responsive to the question, it doesn't give him the opportunity for a narrative.
Okay.
So now if he does say, yes, absolutely, if you're physically in California, damn right, the Constitution applies to you. And so now it's a very specific, we know exactly what his claim is. And now it's easy enough to just say, exactly how does my physical presence or my physical location here in California prove a written instrument called the Constitution applies to me?
Okay.
And I gotta say, I appreciate everyone. We're getting some pretty good numbers here for a live broadcast. And I gotta jump in. I gotta say this. I'm sorry for derailing this, but you guys, we always have to get somebody in the chat that has to do, and this is specifically on YouTube. They're not charging you on their Admiralty law. They're not saying that you're on a ship, for goodness sakes. Can we please stop this Admiralty maritime crap? I mean, if you want to argue
common law.
No, well, if you're being charged in a state court, it's under statutory law. The statutes displaced the common law a long time ago. Some of the principles still are used in court, but for the most part, statutory law has displaced the common law. So let's get back into the role playing before we're really short on time.
Well, let somebody else do it.
We're what?
Yeah, anybody else want to be a judge and restart from the fresh so he can get it better?
If Tom wants to do that.
Come on, tough guy. Get in here.
Is Tom on the line?
Maybe he's not on the line.
Maybe he's not. Somebody else will Stalo or somebody else can do that. In fact, no one is. The dude hasn't. Well, dude, why don't you take over as the judge, since the prosecution typically isn't saying anything at an arraignment anyway?
I could. I'd like to see. I think Joe's in here actually. I'd like to see somebody a little more experienced.
Than you?
I don't have any experience.
Okay.
I don't mind doing it. I always just default when nobody else will.
Well, I would nominate Joe also.
Oh.
Joe, the judge style has spoken. Please stand up, remove your hat, get in here.
No, I guess not. Dude, why don't you do it?
Who are we victimizing this time?
I guess we'll keep going with home bumming unless there's somebody else prepping. If there's someone else prepping for court, shout out.
Yeah, I'll go.
Who's that?
That's Scott.
Okay, Scott, you're on. Okay, so dude, he's got a demur
I got an
pending or
inspection sticker coming up on October 4th.
inspection.
Yeah.
Okay. Okay, dude, he's got a motion to dismiss pending.
I didn't file any motion yet.
You didn't file a motion yet. Well,
No, I haven't.
October is coming. Yeah, you still got a few weeks to do that, so get that filed. Well,
It's my second hearing so far.
the second hearing. So are you going in for an arraignment?
Well, I don't know because they didn't even they just tried to put me on the other side of the bar and tried to start a trial without any type of arraignment.
Are you sure it's criminal?
No, he said it was civil.
There you go. You don't have an arraignment when it's criminal.
But
I mean,
all
you don't
the
have an
other ones
arraignment
I've
when
been
it's-
to for any type of traffic infractions I've had an arraignment.
Well, if it's a criminal infraction, if it's criminal, then you'll have an arraignment. But if they're saying that it's civil, you're not going to have an arraignment. They're not going to be asking you if you how you plea. Really, all they do is ask you if you're paying or if you want a trial.
Right. Yeah, that's what they tried. But I didn't go in the bar, and I asked them what kind of proceedings these was because I didn't understand because I hadn't been arraigned, and then I went through my whole script and just I don't know. He answered questions and stuff, but
Okay.
they just booted me out and set it for another date.
Okay. So, you may have been going in for the actual trial. So let's just say that you're going in for the trial and you have the motion to dismiss pending and you've done your discovery request. They've given you nothing as far as discovery except for a copy of the police report. And so, dude, run them through. So, dude, what you're going to be doing is that you're going to try to move this guy to trial under those conditions.
Sure. But if I make a comment before I do this, is that we've got this many people in here, and why is it going to always be the same people being the judges, right? We need to try, and this is just my opinion, to try and get more people encouraged to do it because they don't realize that they could probably learn just as much by being the judge, especially if they're going through court because they've heard things said. Some of the things that I have said as a judge have been, said to be not very realistic. And I can read them directly off my transcript. It's quite comical when I get run across that a few times. And maybe it's just because they operate a little differently up here or whatever it is. But
Well, there'd be slight variations.
I would like to see more people from the area of the person that's on the call, so they know what kind of judges they're up against, or do we need to be like a total tyrannical judge because people will stumble across those, right? So why is there such a lack of people wanting to take on the judge role?
Am I in?
Maybe a lack of experience.
Sorry.
Am I in?
Maybe a lack.
I'm in.
Maybe a lack.
I'm in.
Okay, someone's got to mute up because it's feeding back.
Feeding back.
Okay.
All right. So, all right.
This is sounding like a 1960s
I got ya.
Floyd song.
All right. Let's not
I'll
have.
play judge if you need it.
Okay. Who's that?
Home bumming it. I'll play judge.
Okay. So, Home Bum is the judge and Scott is the defendant. Okay. So, Home Bumming it, remember, it's supposed to be a civil proceeding and you want this to go to trial and get this crap over with as soon as possible. There's a motion to dismiss pending and Scott. Okay, take it away.
Yes, Mr. Hayward, you're here for a alleged violation of a inspection ticket. How would you plead? Guilty, not guilty, or no contest?
Well, I have a few questions first before I can enter a knowing and voluntary plea. My first question is this a court of record?
Yes, it is.
So it is being recorded. All right. For the record, I'm here under special appearance and under threat, duress, and coercion. I'm not waiving any of my rights. I wish to take care of these matters today. I have an unsigned plea of guilty here, but first I have some questions so I can get clarification, be fully informed of the cause charges against me, and enter a knowing and voluntary plea. Do I have a right to a fair and meaningful hearing?
Mr. Hayward, we don't have that much time in this court for all these questions. If you would like to have a court-appointed attorney, we can appoint one for you, and they will be able to answer any of your questions.
Okay. Do I have a right to a counsel that's not licensed by the plaintiff?
I'm not quite understanding what you mean by licensed by the plaintiff. They're usually licensed by the bar or by the bar association.
Okay. And so who is the bar licensed by?
The bar is an association. It's not like. Would you like to plea now, or would you like to get a public defender to answer the rest of your questions?
Well, I would like to make a knowing and voluntary plea, but I need some clarification before I can do that. And now you said that the bar is a association, but that's not licensed by the plaintiff. So who are they? Under what authority are they acting?
Okay, I got to jump. Hold on. What does the Bar Association have to do with whether the prosecution's complaint has sufficient evidence to prove jurisdiction and force you to participate in the trial?
The state objects due to relevance.
Yeah, they certainly would. So I want to know why you're discussing at this point. You have a motion to dismiss pending. They're trying to force you to trial. Why are you arguing the status of the bar?
Because he had asked me, or he had recommended that I seek a lawyer or attorney of some sort. And so I asked if I had the right to counsel that was not licensed by the plaintiff.
Now, do you think that the judge was being honest in doing that, or he was just trying to dodge and get your attention onto something that's not relevant?
I think he was trying to force an attorney on me so he could just put it through without me having to challenge any jurisdiction.
I didn't hear anything in there where he was forcing you to get a lawyer. That would be really easy to do. He'd tell you to sit down and he would just have a lawyer assigned to you.
May I interject?
Sure.
The point that he could possibly make about bringing up the bar is a very weak argument regarding conflict of interest, because both the prosecuting attorney and defense attorney are on the same team. But that's it, and you might as well just throw that right out there.
Well, you also have to throw out there that, and if we're going to bring up a conflict of interest, there's a very good way of doing it with okay, but we're not going to do that right now. The other thing is considering that what the scenario that we're going through here is that it's a civil traffic proceeding, and the judge himself may not be a lawyer. Like in Arizona, they're not lawyers. You have hearing officers. Yeah. So when I bring up Herbert Pierpan on the show in Scottsdale, he's not a lawyer. So you have to keep that in mind also. So what they're trying to do, and what I got out from what the home bum was doing, and he did it successfully, was get you to focus on something that's not relevant to whether the proceedings are fair or whether the prosecution's complaint is factually sufficient to establish jurisdiction and, so that they can hold you over for trial.
I would ask the judge, why are you so interested in getting me state-appointed defense?
Well, I don't think he's getting at you got a judge who's trying to get you to stop asking questions. And so I don't think it's that he's so interested in doing that. He just wants you to ask. He just doesn't want to hear your questions anymore. So he's going to distract you and get you talking about something that's not relevant. Our focus is on the prosecution's burden of proof. knowing that the burden of proof is on the prosecutor. The motion to
Yes.
dismiss is pending, and you haven't. We've gone on for a little bit here, so I don't know if you've even mentioned the motion to dismiss yet at this point. So why don't we go back to the beginning and, Scott, focus on the prosecutor's burden of proof and objecting and asking leading questions with your objective to have it come out that your physical presence, and where are you located? Is this-
I'm in Maine.
Are you in Texas?
No, Maine.
Oh, Maine. Oh, Maine. Okay, cool. So, and whether your physical presence in Maine is proof, even prima facie evidence, that the Constitution, a written instrument from 220 something years ago, actually applies to you. So keep that your focus, and that's what you're trying to do. Does the prosecution have, are the facts as alleged, are they actually prima facie evidence of personal jurisdiction and subject matter jurisdiction? So let's go to let's take it from the top. All right,
Mr. Hayward, you're here on a violation of a inspection ticket. How would you like to plead? Guilty, not guilty, or no contest?
Okay, well, I have a few questions before I can enter knowing a voluntary plea. And my first one would be, what evidence has the prosecution provided that the statutes and codes apply to me?
Well, the statutes and codes apply to everybody, but if you would like to argue that, that would be something that you would have to prove.
Well, I'm not looking to argue. I'm just looking for clarification on what evidence the prosecutor has provided.
You got to start everything with the word objection.
That's
So,
correct.
but
And just to clarify, we're gonna start
Sorry,
over.
Getting a little echo here.
We're gonna start over, but remember, he's not there for an arraignment. He is there because they're trying to force him into trial, and there's a motion to dismiss pending.
okay. Chester, mute up.
What's up?
Mute
Oh,
it.
I'm up.
Mute it. Mute up. You're making an echo.
Chester, mute up. Okay. I think he's got that muted up. We're good to go. So let's take it from the top. Home bumming it. You're the judge. You're trying to force this individual, Scott, into trial, and there's a motion to dismiss pending that you're not even it's not even in your, you're not even aware or care about it.
Mr. Hayward, you're here on violation of a ticket for, what is this? Inspection sticker. How do you plead? Guilty, not guilty, or no contest?
No. No.
Okay, so
let's now home bumming it. No, that's not what we're doing. So we're gonna
Oh,
Tom.
sorry.
Hey, Tom, can you jump in here as the judge?
It's kind of convoluted right now. I'm to understand that he is. Just give me a quick scenario again where we're going. You
Okay.
have motions on the table, a demur.
Well, a motion to dismiss is pending, and they're trying to, for the second or third time, they're trying to force him into a trial on a civil traffic. Wow, we got a lot of background noise there, guys. The judge is trying to force him into trial on a civil traffic matter, civil, not criminal. So there's no arraignment. And they've already had, where they've spoken about this before. They continued it to, October, and they just want to force him into the trial so that they could take his money. And they want to ignore the fact that there's a motion to dismiss and discovery request at play.
Okay. And I just would like to touch base on something. You said there's no arraignment in a civil traffic situation, and they most definitely have them here.
Yeah, that's what I'm saying. I've had a couple.
Some
And
places
mine was
vary.
as bad as, check this out, no police officer
Hold
and
on.
no prosecutor, a room full of people, like a herd of cattle going in front of this woman judge, a magistrate. And when I got up to her, I asked if there was an officer or a prosecutor, and nope. She says, I'm just here to get a plea today. That's it. And no matter how I argued this thing, she was not having it because she gave me all kinds of excuses. All I have is the ticket. There's no officer here. There's no prosecutor. I don't know anything about it. I have the ticket and I'm here to schedule or ask you if you want to plead responsible or non-responsible. And that's it. If you want to plead not responsible, we'll set it for a trial.
Okay, well, we're beyond
Right.
that here. We're going to just do it as it's a civil traffic. He's already gone through an initial appearance, and here
Okay.
it's the date set for trial. The judge doesn't
Yep.
get,
So she set trial, you're at trial, and I'm the judge, and I'll be just like the judge I had.
Well,
Right.
don't go a little easier on the guy.
Yeah,
Don't
of
let's not
course.
beat let's not do
I-
it doesn't always have to be a worst case scenario.
No, exactly. All right, sir. Again, this is. I see you have this ticket here, and it's your day in court today. I see there's been a plea entered. Obviously, right? We're going to assume there's been a plea entered. There's been
We can for this scenario, but I
Yeah.
have not entered plea yet.
but we just said, Mark said, you're going to assume
Right,
that.
for this scenario.
Oh,
Right,
okay,
right.
okay, all right. So, there's been a not responsible plea entered. I see you want a trial. The evidence. Well, first, I would tell the officer to stand up, raise his right hand. I tell you to stand up, raise your right hand. I'm going to swear you both in, officer.
Can I object on this to try and bring up the motion and how it hasn't been ruled
Well,
on, or how
this-
what ruling
you
it has
do.
been?
What would you do if the judge asked you to swear in? Let's start there because they will.
I would object, and I would say I have a few questions first before we get started.
Or it'd be objection. There's a motion to dismiss pending, and there's a very serious discovery issue that needs to be discussed.
Okay. Yeah, we'll go with that one.
Okay.
Sir, we're here today for a trial. There's been a not responsible plea entered. You wanted a trial. You wanted your fair day in court. Today is your chance to have your fair day in court. And I need to hear the officer's testimony, and then we can get your testimony, and we can decide who's 51% responsible. So please, both of you stand up and raise your right hand.
Well, I'm going to object to that because I have a motion that hasn't been ruled on yet, and I'm trying to get clarification on why that hasn't been ruled on yet.
Sir, we'll get to that. But first, I need everybody to swear in so that everybody's telling the truth today. So go ahead and stand up and raise your right hand.
Well, I'm going to object to that at this moment because I don't want to waive any of my procedural rights.
Oh, well, sir, we gave you the advice of rights form when you walked in, and you read it, you signed it, you gave it back to the bailiff. So you do understand your rights, don't you, sir?
No, I object. I didn't sign anything at this moment up to this point.
Well, in my state, in every court around here, they give you this advice of rights, and all the ones I've seen, everybody gets this so that they can claim that you've been informed of your rights. I have not
Right.
seen a court not do that yet. Are you telling me you went to your courtroom and they didn't hand you anything?
Correct.
Okay, all right, well, then we won't go there. That's fine. So let's continue with where we were at. Again, sir, I'm only here to get a plea.
You're
Again,
going back, and then we're at trial.
They're
trying to force trial.
So it's your fair day. It's your fair. We need to swear you in. I need to hear the officer's testimony, and I need to swear you in. Please stand up. I'm going to ask you this one last time. Please stand up and raise your right hand.
Well, I'm doing this under threat, duress, and coercion because I haven't been informed about the motions yet of why they've been denied, or if they've been ruled
Well,
on at all.
Let's go out of role for a minute, out of character.
Yep.
This is what
Okay.
I like to do, and this is what we've been talking about for a long time. Rather than challenge him or anything like that, say, Judge, I'm not here to testify. I don't know if I'm going to testify yet. Yeah, I'm a defendant. I'm not required to testify, right? And he'll say no. Okay, well, I'm not here to testify, so I'm not going to swear myself in right now. There's no need for me to be under oath. I'm only here investigating and asking questions. Now, I've had the judge actually tell the officer to put his hand down, and this is my one loser. We're not going to get into that, but that guy never testified. So the judge may say that, officer, put your right hand down. Go sit down. and then the prosecutor will start their thing, and I went into a motions hearing just like you did. Now, all right, let's say that happens. The officer's told to go sit down. Neither one of you sworn in. Now the judge says, "Well, sir, yes, I have your motions, and I'll tell you what she said, and I've read them twice. They're very interesting. So, you know what? I'm going to give you your fair day in court today, sir. Go ahead and argue your motions."
Oh, okay. So we're back into the role. Okay. So whose rights am I being alleged of violating?
No, I wouldn't do that. Stick to the motion.
Okay.
You
Well, I
want to
thought
know.
that was part of the motion.
The state would like to answer and rebut. We
but
have a witness.
because the motion to dismiss is based on lack of evidence proving personal jurisdiction and subject matter jurisdiction. Okay, that and the subject matter jurisdiction part goes directly to the elements of the charge. We're interested
Isn't
in
the violation of a right part of the charge?
Yes, but we're interested in the evidence to show that. Now, if you start saying
Okay.
on whose rights were violated, now you've given an opportunity to.
So
at least
how would
be
I word
responsible.
that? How would I say whose rights have I being alleged of violating?
You don't have to ask that. You just have to ask what facts have they presented that show what facts show that even at a prima facie basis that the Constitution and Code apply to me just because I'm physically in Maine.
Okay.
See, the violation of the
Hold on,
legal
guys.
right.
I got to get into this. Mark, this judge would now jump right in again and say,
Okay.
"Listen, today is your motions hearing. You've got motions on the table. I'm trying to give you a fair opportunity to argue your motions. Please don't go off in different directions and tangents right now. Let's stick to these motions. They're very interesting. So go ahead and argue your motions."
Well, objection.
Make your
You're
case.
You're misleading what happened there, ma'am, sir, ma'am. Sorry to. You're mischaracterizing what's going on here. When I'm asking for the evidence to prove the Constitution and Code apply, that would even make a prima facie case against me. That's directly from the motion.
Well, Mark, okay, how about this? This is something we've practiced for a long time. You file these motions. They're very clear, they're very concise, and everything in them is worded the way you want. When you're standing there under pressure and you're scared and you can't think, and this judge is putting this pressure on, they're baiting you when they ask you to argue your motions.
Yep.
Your argument is clearly in your motion.
Yep.
And you'd be best off, and what I would suggest is to say, "Judge, my motions are very clear. If there's anything I can explain to you in those motions that you don't seem to understand, or don't even say that you might not understand, go ahead and let me know. But my arguments are very clear," and then see what they say there.
See, we've talked about this on the show. I like the idea of, especially if the prosecutor's there, and looking right at them and saying, this is why I say never stand on the motion. Yeah, it's well written. Sure, but don't stand on it. Get some dialogue, even if it's considered unorthodox. I want to know, and I know the judge doesn't have a requirement to let the prosecutor answer, but you put the question out there.
Well, that's what we're doing.
Yeah,
That's
but the
what
question
we
is,
say we don't want to argue our motion. The motion is very clear. We don't want to make any assertions at all. You know that.
well, that's why I'm saying you're asking the question. You're putting the question to the judge and the prosecutor. Does the prosecution have the facts that even to prove at a prima facie level that just because I'm in Maine, their Constitution, a mere written instrument, actually applies to me? So you're putting it. I would argue the motion by just putting the question of evidence directly to the prosecutor or the judge, who's ever more inclined to answer the question. It should be the prosecutor. The prosecutor should say, yes, I have. And then, of course, you're getting some discussion on that.
So it'd be, has the prosecutor provided evidence that the statutes and codes apply to me? And that's stated in this motion that I've.
Yeah, well, or you could say, do they have any facts that would show, even on a prima facie level, that just because I'm physically in Maine, the Constitution, a written instrument, which is a fact, a written instrument, applies to me and gives personal jurisdiction?
All right. Well, can I interrupt here? Because I have found that as soon as you mention the Constitution, the eyes start to roll.
Yep.
That's why I try not to say
myself, I try to stay away from that word. Again,
but you're not arguing. I'm
Hold
running low on
If
time
I'm gonna
here.
argue your motion at all, I'm going to stick to your points in the motion.
Okay.
The three main points in that motion.
Yeah, but to get to what you're saying, and we've discussed this on the show before, you can object, at least some of them are going to listen to you. You're not making a constitutional argument. What you're doing is as far as is the statute constitutional? Okay, you're not making that kind of argument. What your argument is from the motion or the demur is the prosecution doesn't have sufficient evidence, so it's an issue of fact. So you're bringing up the Constitution, and yes, I'm not explaining it as well. I feel like I'm standing in court. I'd be clearer, but your position is that the prosecution's claim that the Constitution does apply has no factual support. So if the judge doesn't want to hear anything about the Constitution, so, well, ma'am, if you don't want to talk about the Constitution, I'm happy to do that, but you've got to tell the prosecution to withdraw their claim because they're the ones who brought it into this court, not me. Right? I mean, isn't that what's going on? Isn't the
Right, they're
prosecution?
using the Constitution as the basis for charging you with any type of violation.
It's the basis for personal jurisdiction. It may not be the sole foundation for subject matter jurisdiction, but certainly personal jurisdiction, because territorial jurisdiction, they're saying that their laws, which the Constitution is the supreme law, that Constitution applies to every square inch of what they call the state. So they're the ones that are making, that are bringing in a constitutional claim, not you and me necessarily. We might make a due process violation, but if they don't want to hear a due process violation, the appellate court, will. So it's definitely a point of contention, Tom. You're right that when we do use the word Constitution, something goes off in the judge's head, and it's up to us to object and make it clear we're only attacking their constitutional claim. So if you've got a problem with that, you tell them they can't argue the Constitution. If I can't argue Constitution, they can't argue the Constitution. But if they rule that they can't argue the Constitution, then the judge has to throw it out because the prosecution can't support their claim of jurisdiction.
Well, that's all fine and dandy and all fancy and such, but I'm telling you right now, these judges don't put up with that crap.
Well, yeah,
I heard them say, "Don't bring the Constitution into my courtroom." Yeah. Literally, had heard that said.
Right, and I've heard it too. And so you need to object, though, Tom, and say, "Objection! I didn't bring it up. The prosecution did." Now,
okay, so let's judge what evidence has the prosecution provided that the Constitution and codes apply to me?
Well, Mr. Prosecutor, what evidence have you provided to the court today? Well, we always have to have a prosecutor. We got a couple of good.
Yep. At this point here, the prosecution has presented everything that is required as per State versus Smith and State versus Wesson. I also have the allegation here. We also have the officer's notes. I believe this is all that's required at this point. Am I correct there, Your Honor?
Yeah, I've been sitting here looking through the statutes, and it covers it, sir. We have jurisdiction. So again, that issue's been settled, and today is the day for your trial. So I believe.
Objection. Objection. Is that based on your opinion, or is that based on facts? Because I don't know what facts that he's claiming that he's presented to the court.
Well, sir, and this is the same lady judge that said she read them twice. She says, "Sir, I can actually rule on motions and not even have to tell you that right now. I can mail that to you. So we're going to move on. And I'd like you to please raise your right hand and swear in." The officer stands back up again. Okay. Because that's what's going to happen. They're going to want.
Well, then I'm going to object to it and only do it under threat, duress, and coercion.
Well, okay. I tried that. All right, sir, we're not threatening you.
Wait. I got to go here in a couple of minutes because I'm running a little bit over.
All right.
Scott is missing something here. Now, you're right you've made your objections about the motion to dismiss, and so you don't need to revisit that. You preserve the issue for appeal if it's got to go there. There's something else that you're missing that has to be addressed before you go to trial.
The evidence that the statutes or the evidence that the Constitution applies to me.
But Okay, but what is the technical word for you've got the motion to dismiss, and there's something else at play that has to be determined prior to going to trial?
I don't know the technical term. I guess
Okay.
I'm missing that.
So when we file the motion to dismiss, or the demur, we're also filing it with a discovery request. Now, because this is civil, we don't use the word Brady, but they still are supposed to and obligated to give you exculpatory evidence. So
Right, discovery.
So what you need to do is, now Tom is right in doing it, enforcing it, that they want the cop to put his hand to the square and swear. So you do need to object, but the objection has to be on the issue of discovery.
Well, can I interject again?
No.
In most of these states will give it to you, even in a misdemeanor now, Mark. The lawyers that are trying to defend drunk drivers having a fit because they can't get discovery, you won't get it in a civil case. They have made statutes, and they'll argue it. And you'll have to stand there and argue with or beg the judge basically to have due process. You put them on the spot a little bit with that, and that has helped me. But I've literally had the prosecutors pull those statutes out, and I can show them to you. We had this discussion years ago, Mark, here in Michigan. No discovery is required to be given by the prosecution in a misdemeanor, and none at all in a civil case.
Okay. Now, the thing is, for traffic, right?
Yep.
For misdemeanor traffic, regardless of what the Michigan statutes say, okay, Brady is always required in criminal, period. And that's always required. That doesn't mean they're going to give it to you, but you still have a Brady violation that you need to argue, and you may have to appeal. As far as the civil traffic, California and Arizona, for example, Arizona is a really good example. Civil traffic, they don't have to give it to you until the day of the trial. In fact, I think it's immediately prior to the hearing. So they do have to give it to you. That doesn't, but they still don't give it to you. I mean, I told you we had Pearpan allowed a cop to get away with saying that the judge will, or the hearing officer is going to take care of discovery for him. So Michigan is different than Arizona and a lot of other places. So it's always good to bring that up so that so people are aware. If you are in Michigan, civil traffic, you're not getting discovery, period. Misdemeanor, they're not going to give it to you, but they're still required to give you Brady material. So again, before I go, they have to, if their witness doesn't have personal knowledge of the matters they're testifying to, that is Brady material. They have to tell you that in plain English. I'm calling this witness, and I know he doesn't have personal firsthand knowledge. I have no proof that he does. I'm going to call him anyway. So I'm really sorry. You guys obviously can continue. I have to go. I will have this available at markstevens.net. I'm not going to edit this video at all. It's just going to be the raw video. So we'll keep it up there. We'll do what we can to make this a regular. Well, look, every Thursday at least we're going to be doing this. I'll try to add some other ones, of course, if we're going to do it here. But I do need to go, so you guys can continue. So I'm gonna cut the stream there and then say goodbye to everybody. But we'll be live on the No State Project, of course, on Saturday. So till then, salud.